I'm very pleased as a member of the National Alliance for Parent Representation Steering Committee to have so many of you here from all over the country. As Mimi said, we're super excited to have so many new folks joining us, and we can't wait to see you in person next year. Today, I have been asked to facilitate a conversation about ASFA. And when I was asked to do that, it was immediately clear to me that the topic of the session, unlike some of the many sessions that I think have happened at conferences over the last years about ASFA, this one had to be, we knew right away, about the need for change, that now is the time to take on the harms of ASFA. And we're particularly pleased to be able to talk about some of the exciting conversations that are going on in different parts of the country today. We'd like to connect those conversations a little bit. We'd like to let you know what's happening on the ground, what's percolating, and connect you to as many of the conversations and projects that are happening as possible. There are so many, we won't be able to do them justice. We've probably taken on too many for one panel, but we're going to do the best we can because we really want to give you a sense of the energy and the ideas that are coming to the fore in a way that really just has not happened for the last 25 years. And I know many of you join me in thinking that it's long past due and our time is here. I would like to start by letting you know who we have here with us on our panel. Allison Durkin, who is with the Criminal Justice Advocacy Clinic at Yale and the author of what I think is really a model report on incarcerated parents and termination of parental rights, is joining us. Hi, Allison. We also have Deanne Gillespie, who is the founding partner of an Arizona firm, Gillespie Shields. That's a full-service firm, but it has developed a particularly ambitious and creative appellate practice around termination of parental rights cases. So we wanted Deanne to speak to you about how we can push back on ASFA through appeals. And then we have with us Ashley Albert. Hi, Ashley. Ashley is a member of the steering committee of the growing Repeal ASFA campaign, a very exciting grassroots campaign that Ashley is going to tell us about. Ashley is also somebody who has been directly harmed by ASFA. She's going to talk to us a little bit about that and how she took the harms of ASFA that her family experienced and turned them into efforts to help others. She's been involved in many advocacy efforts. I won't mention them all, but she's been a board member of the Pacific Northwest Alternative Peer Group, and she served as the parent engagement coordinator for the Washington State Parents for Parents program. And now, as I said, she's leading the charge as a member of the Repeal ASFA campaign. So very pleased to have you all here with us. I am going to start us off by speaking first about why now is the time for change, and not only why it should be the time for change, but why it's really the time that change is possible. Again, really, I think for the first time in 25 years, I know I, for one, want to celebrate ASFA's 25th anniversary next year by having a going away party. And we want to talk about how to make that happen. I know that many of you, maybe all of you listening, are familiar already with the harms of ASFA through your day-to-day work on the ground. And nonetheless, we do want to focus on some of the numbers and bring those to life. What you're seeing on the ground is not unique to your jurisdiction. It may have its own flavor in your jurisdiction, but it is part of a nationwide problem. Marty Guggenheim, when he spoke the other day, gave some of these numbers. I should know better than to ever speak after Marty about anything, but I think it's worth reiterating some of those numbers because part of what we need to do is to get across not only the depth of the problems of ASFA, but also the breadth of them. And that is what these numbers here show. ASFA was created purposely to increase adoption. And of course, many celebrate the numbers of adoptions that ASFA has accomplished. And I don't doubt that some adoptions are worth celebrating, but I think that part of our project over the coming years is to really separate forced adoptions from voluntary adoptions. Marty mentioned that language matters. I think this is the kind of place where it matters. When we say that ASFA has achieved 1,161,500 adoptions, what we mean is that it's achieved that many permanent family separations. And we need to talk about them as the forced separations that they are. In particular, I think that we need to talk about this new creation that ASFA left us with, the legal orphan. This is a shameful invention of the United States. And the fact that at the moment there are over 70,000 legal orphans is something that we all need to be talking about more. I'm going to talk in a few minutes about one specific legislative effort that we think might get at that particular problem. But it's certainly a problem that we need to be getting out there. We want to be clear that this is a U.S. endeavor. When we talk about the number of kids that are adopted, that's in the United States. And just like with mass incarceration, just like with the criminal death penalty, the United States is the only country that has embraced the civil death penalty. And that is part of the message that we need to bring out. And of course, that comes not only with emotional costs, the incredible emotional toll and harm to families, but with financial costs as well. And that's why I'm highlighting here the astounding $2.6 billion that we spend every year subsidizing the 469,000 adoptions that are already being supported by the American government. So those are some of the numbers that reflect what you're seeing on the ground. And of course, all of it is more disturbing because of the racial disproportionality. That's not to say that ASFA doesn't hurt countless low-income white people. We know that it does. But it's like many other systems, that harm on everyone is driven by the racism of the system. And it is, I think, the real racial reckoning, the reckoning around racial injustice that we have started to see in the past year that has made a new kind of change possible. And what we're starting to talk about is how many of the structures that have been implemented through American history, but particularly in the 90s, need to be taken on now. It is not an accident that the Adoption and Safe Families Act was passed in the same era as the crime bill and the welfare reform bill. And the racist rhetoric that led to the first two led to the third. And I think we can draw hope and inspiration from the fact that if we have been able, as a nation, finally to grapple with some of the harms of the mass incarceration that came out of that crime bill, and we have been able to start to support families again through tax credits, and other material support, we also are at a place where if we can explain to people that the source, the origins of the Adoption and Safe Families Act are the same, we can say analogously that it is time for change. The quote that's up here now is one that Richard Wexler has surfaced in his work to show the painful origins of the Adoption and Safe Families Act. One doesn't need to look hard to see what was going on when this was passed. It was using adoptions to actually achieve family separations. That's what the bill was about, and that's what we're now ready to take on. The effort is taking many, many forms. I think it's only just starting, but we are particularly excited here in New York that this is a battle that we're seeing on the streets. And so as folks have come out over the last year to talk about all kinds of problems of racism here in New York, some of those protesters are not just talking about Black Lives Matter, they are talking specifically about Black Families Matter. These are small protests relative to others so far, but they are growing and they are being heard. This is a photo from one of several protests that we've had here in New York. And I'm sorry, I've lost my ability to shift pages here. Let's see. Maybe my tech friend can help me with, I've lost there we go. The page forward on tech is not my thing, so apologies there. But the series of protests that we've started to see in New York that are specifically aimed at demanding change in the family regulation system have been accompanied by a poster campaign. So on some mornings in New York City this past winter, folks woke up to seeing posters that called out some of the harms of the family regulation system. This is one here, a particular favorite of mine. This is a billboard that was up in Harlem for over a month early this year, telling people that the time for change is now. And we are hearing this again and again from a growing number of organizers and activists and allies. And so the Movement for Black Lives, for example, has specifically called out not only the family regulation system, but termination of parental rights as one of the things that really needs to be changed, not someday, but now. The Black Public Defender Association, similarly, explicitly calling for the repeal of ASFA. Here are some of the tweets that the Repeal ASFA campaign that Ashley's going to tell us more about have been sending out, so that you know the social media world is starting to hear about this as well. At the same time, calls are not only coming from the outside. As Marty mentioned, we've had some really crucial calls from inside, and cannot underestimate the significance of the fact that our former associate commissioner at the Children's Bureau, Jerry Milner, has said we need to repeal it, pure and simple. And these are calls that we need to repeat and get out there and be inspired by. And, you know, there are many, many ways to respond to these calls to action. We're only going to give you a few here. But I'd like to, in particular, talk about some of the recommendations that have been put forward by the group United Family Advocates. Kathleen Kramer, who many of you saw a few moments ago in the discussion with Dorothy Roberts, is the co-chair of United Family Advocates. It's a bipartisan group that was founded by Diane Redleaf and is now chaired by Kathleen and by Andrew Brown. And United Family Advocates has been calling for change and responding to the calls for action. And I'd like to tell you a little bit about the specific recommendations, legislative recommendations, that UFA is making today in conversations that are happening right now in a way that they weren't happening 5 years ago, they weren't happening 4 years ago. I mean, they were not happening a year ago, but they are happening today. And I think that it's fair to say we have a different Congress than we've ever had before. There are 56 members, just as an example of the change. We have 56 members in the Congressional Black Caucus. That was not true when ASFA passed, and I don't think that it would be able to pass today. And I think that the caucus and the many others in Congress who are calling for a new time, a new relationship to supporting families, are opening the way that these kind of recommendations can be heard. I am particularly thrilled that Congresswoman Karen Bass of California, who has been a leader on foster system issues for many years, has said in particular that it is time to address the harms of ASFA. And so these recommendations were developed largely in response to that recognition that folks on the Hill are saying we need ideas. We want to hear how to fix some of the unintended consequences that we're dealing with today. As you can see from the small print on this slide, I'm not going to be able to go through all the 10 recommendations that UFA has come up with. I urge you to, they're described in more detail in an op-ed in the materials. I hope you'll go there and look at them. And we're also going to drop into the chat contact information if you are interested in joining United Family Advocates or in learning more about their work. Please do contact through the contact information that's there. Because I can't possibly do justice to all of them, I do want to talk in particular about some of the key recommendations. The recommendations go soup to nuts. They start from, we need to change the standard, the federal standard at which we're going to financially support family separations. And that's why we start here with, there needs to be a compelling reason. That is not in our federal law right now. There needs to be imminent risk of serious harm to justify the grievous step of separating families, even on a temporary basis. And so that's recommendation number 1. But the heart of the recommendations, I know you won't be surprised to learn, really go to the fundamental flaw that is built into ASFA, that motivated ASFA. I know many of you, like me, were found Dorothy Roberts' comments a little while ago really inspiring about the need to get to the foundations of the problem. So the foundations of the problem with ASFA have to do with the assumption that a clock, a calendar, can ever tell us that there comes a moment when it is in a child's best interest to be separated from their family. And that is just a fundamentally flawed piece of reasoning that we need to reject. And so the UFA recommendations do call for the full elimination of timelines. And until we get there, talk about, at a minimum, giving exemptions for parents where they're incarcerated or they're engaged in drug treatment programs. But the fundamental idea is that we have to shift from the notion that separation of families, permanent severing of family ties, should ever be the default, should ever be the thing that we are financially incentivizing. Remember the numbers: 4 times more children end up termination of parental rights in the US than England. Well, when you're giving states bonuses to achieve adoptions, that's not surprising that that's what you're going to see. And we need to fundamentally change that. Dorothy also spoke about building and not just tearing down. Well, one way to build would be to give bonuses for reunification, the same way that we've been giving for the last 25 years bonuses for adoption. We need also, when reunification is not possible, to not think that termination is the only alternative or the best alternative. And I know a lot of folks have started working toward promoting guardianship as at least one alternative that often can allow children to stay with extended family members. And the obsession with adoption that we've had since ASFA is really what needs to end. I want to mention in particular, because it goes back to the particular harm of creating legal orphans, that one of the recommendations of UFA is that it's actually, even if you want your system to pursue some adoptions, there is absolutely no reason that you have to create legal orphans on the way to doing that. And so we recommend transferring rather than terminating parental rights. I mean, one might think about why we even use a term termination when it comes to families, a term that better applies to contracts. Terminating parental rights is never a positive thing. If there comes a time when we need to transfer them, we could transfer them to adoptive parents without ever having created the possibility of all of those legal orphans leaving our system without any connection to an adult. And my time is running short, but I do want to focus on one other of the recommendations, which, well, first, actually, I pause a moment to say that much of what I just said is reflected in a really compelling way in a recent information memorandum from the Children's Bureau. And I hope if you haven't seen it already, you will take a look. It's in our materials for this session. And I think that those of us who are working for federal legislative change are going to be using this memorandum over and over again. But I also think those of you who are fighting in courtrooms every day can be using this to explain to dependency judges why ASFA is not only wrong, but it's being misunderstood. It doesn't have to create this pressure for adoption when that's not in a child's best interest. So please do take a look at that memoranda. But the last of the recommendations I wanted to be sure to touch on, because I don't think it's gotten enough attention yet, is that even when there are adoptions, somehow adoptions out of foster care are being treated completely differently than voluntary adoptions are. And we need to learn the lessons that the private adoption field has learned. Approximately 2/3 of private adoptions now involves post-adoption contact with the family of origin. While we know in most jurisdictions, post-termination contact with families of origin is highly discouraged after ASFA, if not absolutely prohibited. And that is an additional harm on top of the others that we really need to fight back against. I know there are state legislative efforts around that, pushing for post-termination contact, but it is also something we could achieve through federal legislation by incentivizing it the way we incentivize those adoptions in the first place. I'm gonna pause there. Much more to say about federal legislative efforts, but we do want to be sure to talk about some of the exciting efforts that are going on the ground in different states. We hope that you will take this as inspiration to connect to what's being done in your state or start things if it's not happening there yet. I am very pleased to turn it over to Allison Durkin. As I said, Allison has been in a clinic at Yale and co-authored a report that is directly leading to legislative change in Connecticut. I'm going to let you hear directly from her about that. Allison is going to graduate from law school next week and has already, I think, accomplished more to combat ASFA than many of the more seasoned lawyers I know. So thank you, Allison.
Thank you, Chris, for the introduction and for the opportunity to speak today. Really glad to be speaking with all of you. Our team began developing the report that Chris mentioned, Incarcerated Parents and Termination of Parental Rights in Connecticut, in September of 2020, so the start of this academic year. Today I'm going to be describing a little bit how we developed the project and how it's fit into broader in Connecticut related to ASFA. My hope is that this can be generative of some ideas for how you might approach ASFA advocacy in your own states. And I just want to note that this project really emerged as a partnership between our clinic, Criminal Justice Advocacy Clinic at Yale, and the Connecticut Voices for Children organization, as well as the Connecticut Children with Incarcerated Parents initiative in the state. In the virtual room with us today are some of those individuals, my co-authors, Destiny Lopez and Eleanor Roberts, our supervisor, Professor Miriam Gahara, and we're also particularly grateful to Emily Byrne and Lauren Ruth and Eileen Keys of those different community organizations. So to give you a sense of the scope of the work and our process, I'm going to speak today in terms of the timeline that we followed, and I'm just going to share my screen for a few minutes here. So to give you a sense of that scope, our timeline began with our clinic in September, but there were a few other key steps before our student team even got involved. In the September of 2020, in the summer, rather, before September, our clinic supervisor established this partnership with Connecticut Voices in our clinic to work on issues at this intersection of incarceration and children's rights. We had an amazing undergraduate who did some preliminary work at this intersection. And then our student team really stepped in September. So when we began our work, we were considering a few different avenues for advocacy, but we decided on this project really informed by those conversations with community partners who were already doing work on ASFA, who had previously introduced a bill related to ASFA. And so we knew that the goal was going to be state legislative advocacy, and we wanted a work product that was going to support that goal, and something that we felt like as students also really lent itself to our skill set. So we decided we were going to do a policy paper of some form. Initially, we thought it might be about 10 pages. If you've taken a look at it, you'll notice it's closer to 40. And a lot of that is because of what we learned in the next stage of our work, doing research throughout October and December. We began this work very much, starting at the beginning. We started doing research into federal laws, state laws, trying to understand how they interacted, legal scholarship, policy work, social science research. There was a lot to learn, and it will come as no surprise to any of you that particularly critical in this process were conversations with people who are directly impacted, who are incarcerated or formerly incarcerated, who are working with individuals who are directly impacted. I'm grateful to some of the people who I think are in the room with us today, in fact, who we spoke with throughout this process. And we found that, in fact, sometimes our research would reveal new problems we hadn't really anticipated. For example, lack of data is a really big problem in Connecticut. It's one of only 7 states in the country that does not publish statistics on the average length of incarceration. So as we were drafting recommendations, we added one that was targeted towards that problem of collecting more data, naming what data was missing, and describing who we thought should be collecting that data. So we ultimately produced a full draft of the report in about December. From January into January and February, we had different feedback from different partners and those with expertise. And throughout that process, we were really trying to keep in mind who our primary audience was, legislators, which also means that if you take a look at our report, you'll notice that we use phrases like fiscal responsibility because we were really trying to target that particular audience. But of course, in your own states or communities, the audience and the goals might be different. In March, we published the report, and then we really began our advocacy, our legislative. So we first had a press conference the day that we released the report. And the purpose there was to generate some buzz and momentum for the legislative work that was to come. And there we really relied on the expertise of the Connecticut Voices for Children. They set up a virtual press conference for us and led the charge there. The press came. We were able to put out some press releases with quotes through Yale Law School and through Connecticut Voices. That then led to some press coverage throughout the state. And then there were 2 bills that were ultimately introduced this session that were related to ASFA change in Connecticut. So I just want to describe those for a few minutes. And for those who aren't familiar with the legislative process in Connecticut, just to give you a brief overview, the way it works is that there are typically many different bills that are introduced this year in particular because it was related to COVID and because the session last year was cut short. And typically you need a legislative member to sponsor the bill. The bill goes into committee. Some bills are selected for hearing, and then some bills are selected to go to a full vote. So there were 2 bills that we were involved in this year. One was related to free phone calls for those who are incarcerated. Connecticut currently has the highest rate of any state for phone calls for people who are incarcerated. And that was a bill that was begun by a different coalition, but we wanted to make sure to highlight it in our report because of how related it was to this ASFA advocacy. And the second bill was focused on collecting more data. And the idea was that this could be an initial step on the process to passing, hopefully, more robust reform. So if you're thinking about legislative advocacy in your own state, one thing you might think about is who that coalition is that's going to be in support of your bill and bringing those individuals in, especially if a bill goes to hearing. So we and our community partners, among others, were submitting written legislative testimony in support of both of those bills. Then in April, we continued some more legislative advocacy. We had reach out from journalists, different community members. One key group that emerged as an ally were doctors in the area. And there was one doctor in particular who reached out to us and said, this is an issue that I see with a lot of my patient population, and was interested to learn more. And I think it was helpful just to think about future advocacy in the state and how they could be a really valuable ally for future legislative advocacy. We also produced an op-ed, which is included in the materials, I believe, as well, if you want to take a look. And that was really premised on the report itself, but of course it's much shorter. So we were really careful about how we framed that piece because there was only so much we could say. We decided to settle on a framing that was really related to family separation, since we think that that's a term that's now entered the national vocabulary. And we also made sure to send it to a publication that legislators tend to focus on here in Connecticut. So we were trying to keep in mind our audience throughout the legislative advocacy process. We also did an interview for Connecticut Public Radio as well. Apologies, I think my screen has frozen here. I hope you can all still hear me. In May and going forward, our clinic's role has really come to an end, but we're hoping that our report will continue to advance the conversation. Our community partners will continue to sustain this advocacy long-term and hope to introduce another bill in a future legislative session. One piece of good news is that that free phone call bill did pass the Senate yesterday, and we're hopeful that that will get passed and will become law shortly. And just to conclude, I wanted to share some final thoughts. For our teams, there have been some key takeaways. First, about the importance of strategic allies. Second, about thinking about who that target audience is. And third, about developing framing with that audience in mind. In our experience, we found that even a short-term project could really bring attention and create momentum around an issue. But of course, the problems are going to be different in every area, and your organization might have different goals or resources. One thing that you might think about is partnering with a law school clinic in your area, or bringing in a fellow if you want to do some short-term systemic advocacy. But no matter what state you're in, Chris spoke to federal advocacy. There is a lot that states can do through policy and through state laws, even if ASFA is still in place. So hopefully hearing a little bit about our team's experience gave you some ideas for your own advocacy, and really look forward to any questions that you all might have. Thank you.
Thanks so much, Allison. Really appreciate your bringing to life the practical ways in which even those of us who don't have as many resources as we'd like can start to take those discrete steps that are part of the larger change. I think it's a wonderful example of what Dorothy Roberts was just talking about, non-reformist reforms, that we need to take these kind of steps to get to the larger vision. So thank you for that. I'm going to turn it over now to Deanne Gillespie. As I mentioned, Deanne and one of her partners, Christina Reeves, who couldn't be with us, but we're thinking about today, have really taken their appellate practice around termination of parental rights to the next level with an ambition and a creativity that's just very exciting to see. So thank you, Deanne. We really would very happy to have you here speaking about that today.
Well, I've already learned a lot in this session. Chris, the points you made in your PowerPoint and Allison, I'm inspired by what you're doing with the students. And I've often thought, we have formed a nonprofit called Parental Rights Institute of Arizona that's just in its infancy. And I have often thought that mobilizing the bright students at the ASU Law School or the U of A would be a very good help. And as you spoke, it gave me tremendous ideas in that direction. So I appreciate it. And I think I would like to speak to you later. Here in Arizona, I represent a lot of families that are caught up in the DCS system, and I've unfortunately seen some terminations. In preparation, and I'm in that fight and war a lot. So Christina's done a lot of the appellate work. She can't be here today, but she's amazing. But I would like, in her absence, to share some of the things that are happening in Arizona. As I prepared for this and read more carefully some appellate opinions, I was delighted to see in your materials, you have a case called Alma S. This is 2018. It's about termination of parental rights. In the dissent, Justice Bullock practically says and calls out for legislative change. Listen to this. He says in his dissent, Mother had not argued that the statutes violate the Constitution on their face or as applied. If she had, he wouldn't have been he would have voted to overturn the termination. He goes on to say that the framework for terminating parental rights articulated by the court does not provide the fundamentally fair procedures the Constitution requires. That's a justice that's saying, get some legislative change done. And in his opinion, in his dissent, which is multiple pages, which is in the materials, you can read it. He calls out with a great deal of legal framework the fact that the fundamental safeguards that must be there for parental rights. It's a tremendous dissent, and in it too, Chris shared some statistics about what this bad federal law does. Justice Bullock gives some statistics in Arizona, and I'm not proud of it being from Arizona. He says that from 2007 to 2008, petitions for terminations encompassed 510 children and 484 were granted severances. Let's fast forward to 10 years. What does Arizona have going for it? In September of 2017, we had 3,097 terminations filed, with 3,095 granted, 99.94%. Justice Bullock doesn't hesitate to talk about what that appears. He says, these statistics by themselves do not demonstrate that deficiencies exist in individual cases. But he goes on to say this, they do, however, counsel that we should take great care to ensure that our termination of parental rights process has not become a railroad with no stops and only one destination in which judges act as mere conductors. Thank you, Justice Bullock. And so, with this opinion and being asked to speak today, I called Christina and I said, it looks like one of the first agendas is to get some legislative reform. Justice Bullock has laid the framework for us to call out some of these termination statutes in Arizona as being unconstitutional. He's laid it out. Christina's good work also found that we already had in Arizona, we've got a law in our books for 10 years that nobody was looking at because it wasn't under the child welfare statute Title 8, which is where child welfare is. It's in Title 1. But listen to the language that if attorneys took to heart could be used. The parental rights protected says that this state, any political subdivision of the state or any governmental entity shall not infringe on these rights without demonstrating a compelling government interest, narrowly tailored, not otherwise served by least restrictive means. That goes to transfer of parental rights. That goes to guardianship. That goes to many other alternatives that should be available that Chris talked about, instead of just terminating parental rights. There are laws here that can and should be used. We had an important opinion come down. It wasn't our firm's case, but it was in Donald W. That is in your materials as well. In the Donald W. case in 2019, May of 2019, the court reversed a termination and indicated that you can't just terminate based on 15 months. The court, Judge McMurdy authored the opinion that says there have to be diligent efforts to show that you provided appropriate reunification services. Diligent efforts. And Judge McMurdy, and I happen to have talked to the law clerk who was with McMurdy, who did all of this work, and she advocated to the other panels to have this opinion come out. I didn't know that, but I was calling her on another matter. I talked to someone who knows the law clerk. It was a law clerk, a recent law grad that did the thinking for this and brought it to the justice's opinion, and they recognized it and authored this opinion. It's a published opinion. It's very helpful. And in this opinion, they go back behind the dependency finding. They criticize the dependency finding, and then they move forward and they set aside the severance. Amazing that they undid and went back and unraveled this situation. That's your Donald W. case. Recently, we had some amicus briefs help us. If you look at the Jessica P. case that just came out in July of 2020, this is a case that Christina briefed and argued, and it indicated that the ADA applies to parents who are involved in the system. We represented a mother who I came in late in the case. Jessica has a low IQ, but she's a loving mother. Her family had never been involved in DCS in the past. By the time I got involved, her little boy Hunter was in a foster home that was more bonded. Does that resonate? And anyway, her rights got severed, but we're not done with that. And we did get a published opinion that they should have applied ADA. Why shouldn't have that been applied to Jessica? There's a civil rights case that's being launched on Jessica's behalf because of that violation. And I just talked to Christine yesterday. The state's trying to say, well, it's res judicata. And Christine reminds our co-counsel, no, it's not. The federal law is the final arbiter. The states can't say whether federal law was violated or not. And the ADA is a federal law. So Jessica P. is in your materials as well. I don't have much more to say at this point in time. There's some good stuff in your materials. Oh, yes, the amicus briefs. Reach out for help. We did, and if you look in Jessica P. in the opinion, you will see that. Thank you, Christine, and the Family Defense Clinic in New York. Thank you for others, the Disability and Civil Rights Clinic in New York. If you've got a good issue, reach out to bolster it with those who are well-informed and who can help bring credibility and heighten it. They were willing and they did, and I think it made a difference in getting this published opinion in Jessica P. I'm going to turn my time back, but again, I'm really grateful to be able to be part of this. I've attended the conference a couple of years, and I always come away with enriched information that has helped me as I'm on the ground helping families here in Arizona.
Thanks very much, Deanne. And, one of the very exciting components of Deanne's work has been bringing amicus briefs to state courts on these issues. And I do encourage everyone who works in appeals to, if you're not on our national listserv, set up through the ABA Center, please join, and that can be a way to connect to others who are working on these appellate issues, and who may be able to offer that kind of amicus support that will lift the conversation from being not just about the individual client, but letting the courts know, and educating them on these numbers that they really need to have. So thank you, Deanne. I'm very pleased now to turn it over to Ashley Albert. As I said, Ashley is a very experienced parent activist and advocate. She is on the steering committee of the Repeal ASFA campaign, an extremely exciting new campaign that's being built right now as we speak, and Ashley's going to tell us about it. And Ashley is going to share her own experience of the harms of ASFA, and how she has turned those into a calling to push back and keep those harms from being inflicted on others. So thank you for being here, Ashley.
Thank you, Chris, and thank you, Allison and Deanne, for providing that useful information. My name is Ashley Albert, and I'm a parent leader from Washington State. I'm here to talk about the campaign to repeal ASFA and also my own experience with this law. So I've had the opportunity to see the system on both sides. I aged into foster care when I was 9 years old, and I aged out of the system when I was 18. And I came back into the system when I was about 23 years old as a parent. And at that time, my case had been open, went from voluntary services to a dependency being filed to termination. And that happened over the course of between 2011 all the way until January of 2016, ending with an open adoption to two of my youngest children and a third-party custody with my oldest child. So when I came into the system, I was totally confused. I had no idea what was going on. I had been told that I had untreated mental health. I have been seeing doctors and IEPs, and my grandmother, from my take, did everything in her power to provide me with the services to help me not suffer. And so to be told that I suffer from untreated trauma was a little bit baffling to me, because I had rotated through counselors and psychologists and different services throughout my entire life. What they failed to say was that what I later realized, that untreated mental health was actually untreated childhood trauma that we all know to be adverse childhood experiences. And so as a result to those three laws that were implemented in the 90s, unfortunately, my family was impacted by all of them. And so my main focus is the Adoption Safe Families Act, and how that same law that was intended to protect me from my mother and that put me into the system as a child was the same law that took my children away permanently. I did services, 2 rounds of services twice. My children had, like I said, been in foster care for 5 years. They filed to terminate my rights. I did everything that was asked, including visits. But I guess because of this 1522 rule, this law, my children have been lingering in foster care for a long time. But the truth is that while they called it lingering, I called it continuing to push forth the efforts to do and rectify whatever it was they wanted me to do, jumping all their hoops to get my children back. And I jumped as high as I could. And regardless of how high I jumped, it still wasn't good enough because of this law. I was prepared to go to trial for the termination of my rights. And before I went to trial, there was a settlement conference. I had been told at that conference that at the trial, there was 50 witnesses that were going to be testifying against me, going all the way back to my pediatrician who delivered me at birth. I didn't know what that meant. That scared me, not as much as it made me angry to want to fight back. I had no idea what was being. I didn't understand what was being used against me in regards to my own story of why I couldn't parent my children. And I had been told that if I didn't sign these papers, that I was going to lose the trial, and if I lost, I would never see my kids again. For me, at the age of 25 years old, I had never. I had a lot of trauma, and I've been very close, regardless of whatever had happened in my family. The ties between me and my family were very, very tight. The bond. I personally had never been separated from my grandmother, which is my mom's mom, for long periods of time. So although I may have not had my parents, I did have some type of family connection. So to hear that I would never see my kids again was the scariest thing that I could ever try to wrap my mind around. And I asked for alternatives to the adoption because I thought that adoption was for parents who really could not provide for their children, or parents that felt like their children were better off with someone else. That was not my story. I wanted to continue to try to challenge myself in those obstacles that I have been against that wasn't really hindering my parenting, but my ability to just be coherent and participate as a human being in life in general. I needed a lot of support, and I was willing to I was willing to do what was asked of me. The truth is that when sharing information, that information was used against me to prevent my children from not returning home. And that caused a lot of conflict between my family and my community because they didn't understand what was being said in these conversations. At the settlement conference, I just remember I was so angry. I didn't have any family. I didn't have any. I didn't really have any trust in my own legal representation. My own attorney had told me that she hadn't had the time to read my case because my case had 28 to 29 volumes, page 300 to 500 pages. I later found out that that was my life on paper, and it would have been really helpful to have someone who was representing me to really be interested in going back and looking at that information. So out of fear of not seeing my children again, and out of fear of just losing that connection with my children, I signed the papers after trying to negotiate a third-party custody and a guardianship because I had been placed in guardianship with my grandmother. So I knew a little bit of the language and the lingo and the process of the child welfare because of my own experience as a child, and then my grandmother being transparent with me about what was happening through that process. And so I knew how to advocate a little bit for myself and my kids because of how my grandmother advocated for me. I remember being really angry at that settlement conference, and the retired judge who was the litigator for that conference had told me he didn't agree with my children being adopted because of the age my children were. They were old enough to have known who I was and have built a relationship. And he believed in his mind that if this open adoption would have went through, whether I would have been able to still have and maintain contact with my children, that it was going to cause harm to my kids because my kids already knew who I was, and we had that parental, maternal relationship. He tried to get them to change their mind and bring up different facts between all the players and stakeholders in the room. And I remember when he came back into the room and told me that he didn't, that they wouldn't change their mind and they wouldn't budge. And so I stayed in suffering for about a year, with inflicting harm on myself, emotionally, physically, and spiritually and mentally, because I punished myself for not being able to advocate enough and loud enough and have enough power to secure that relationship with my children on a piece of paper. So in 2000, after signing that paper in 2018, I went to trial in the state of Washington and became the first person of color to legally enforce and modify an open adoption agreement. It had been 1 year and 11 months since I had seen my children. Until this day, that order is not being followed. I am not still able to see my children. I'm still trying to enforce the open adoption agreement. These things are not enforceable, and there's no one to hold the adoptive parents accountable when they're not being followed. I have to deal with the emotional aspects of my children whenever I do get to see them, and the questions of why don't I come around enough, and why don't I call? They are young kids, 12 and 10 years old, and it is not in my in their best interest for me to try to explain the laws in place that prevent me to not be able to see them. And so I take a lot of that pain that I have, and not only in helping others in their experience with child welfare or mental health or incarceration or anything, homelessness, but I joined the Repeal ASFA campaign because I wanted to hold governments and systems accountable that were punitive to BIPOC families and children. So I had came across these amazing women in Philadelphia in 2019 at a convening, and I began to first learn about abolition and the difference between repeal and reform. I have been working on the side of reform and child welfare work, and did a lot of that wholeheartedly and genuinely, and still am proud of the work that I've done. But until I met these women in Philadelphia and these activists and formerly incarcerated women of color, I have found home, my place. I found my tribe. I am a person that has been impacted by the Adoption Safe Family Act by not being allowed to be with my mother or my children. And I've joined and I'm a proud member of the steering committee because I want to repeal ASFA and its harms that it causes on BIPOC family and children. So with the steering committee, we've been meeting for over a year, doing some presentations, and we are in the process at the beginning of our committee and building out this campaign. It's going slow and steady. We are in the process of hiring a campaign strategist coordinator, and soon we will begin to start onboarding and growing a list of interested people and members. We started a social media following around Adoption Month. We are using beautiful and meaningful artwork. The Repeal ASFA campaign is committed to ending harms of the Adoption Safe Families Act. Abolition perspective includes growing new, better alternatives to support families and run by those directly impacted. If you would like to support the Repeal ASFA campaign, please follow us on our social media. I'll have Chris put that in the chat box. And you can hear more about the campaign and steering committee at the Columbia Symposium on Child Welfare Abolition, June 16th through 18th, and reading the steering committee's related article in the Columbia Journal of Race and Law. Also, you can look for us at the Free Her convening by the National Council for Incarcerated and Formerly Incarcerated Girls in the fall. I just want to thank all of you activists and wonderful advocates who have been doing this work long before I came. And I'm so glad, and I am proud to say that I plan on repealing systems that are carceral to BIPOC families and replacing them with restorative justice practices so that government and communities can begin to heal. Thank you so much for allowing me to be here with you all today.
Thank you, Ashley. I feel so lucky that you're a colleague in these efforts and a friend. And I know from what's going on in the chat that that your words have really inspired folks who are listening today. So really appreciate that. And I think that I speak for many of us, the lawyers who are here, when I say that we know that one of the largest steps in this fight against the harms of ASFA is going to be figuring out the best role for lawyers, social workers, and other advocates to play in supporting folks like you and the communities who are being directly impacted. And we want to figure out, and we need to do the work to figure out how best to do that. So thank you all. We only have we don't have too much time for questions. There is one question in the chat that I did want to take on, which is the question of what's the role of ICWA, the Indian Child Welfare Act, in these discussions around ASFA, and should ICWA type rules be used in every case? I think that's a very important question that many of us have given a lot of thought to, and I think needs to be part of this conversation. What I will say is that I think many of us, certainly at United Family Advocates, but I know in other groups around the country, really want to draw on the lessons of ICWA and maybe on some of the language of the ICWA statute. So there have been conversations around maybe taking the active efforts requirement that's in ICWA and bringing it over and saying we really need to make active efforts in every case. At the same time that we want to bring the benefits, I think that there is broad understanding that ICWA hasn't accomplished its fullest aspirations yet. And so I think that those of us that certainly who are working on the federal legislation want to take the lessons of the importance of the process, what could be called a truth and reconciliation process of bringing out the harms that were inflicted by the American government and state governments on indigenous peoples in the United States. There had to be a real education process to acknowledge those harms before the first steps could be taken. And I think part of the work we're talking about is doing the same kind of education and acknowledgement of the harms of ASFA. At the same time, we really do want to also know that putting words on paper is not enough, and that ICWA has not realized its full aims yet. And so we want to take the lessons, I think, for good and for cautionary purposes. One other question that we anticipated but haven't gotten, but I'm going to answer it anyway, is that Allison and Deanne and I all drew on numbers and the extent of the harm that is shown through the statistics. And I did think we might get the question of how folks can lay their hands on those numbers. Allison pointed out that sometimes they're not available, and if they're not available in your state, you may need to do advocacy to push to make them available. And that can be advocacy, non-legislative advocacy with your agencies, particularly those that are saying that they want to take on structural racism. Well, one very direct first step that they need to do is to share information, and advocates need to be demanding that. If agencies don't agree, then the kind of legislative change that Allison talked about may be necessary. But I also want to make sure that people know that there is a ton of information about individual states that's available because it's required to be supplied to the federal government. And so the AFCARS, AFCARS data is available online. If you simply search for AFGARs, you can find state-by-state data. And imagine if, like Deanne and her colleagues, you're able to put those numbers in your briefs. I think that's going to be one of the key steps for the education process that we're talking about. So just seeing if there are any other questions there. I think pretty much time for us to wrap. I want to really encourage folks to follow the social media tags that we did put in the chat for the Repeal ASFA campaign, a really wonderful place for advocates to figure out how they can support activists on the ground. And to follow up if you're interested with United Family Advocates, also the information in the chat, if that's the kind of work you want to do. But whether you choose federal legislative efforts, state legislative efforts, appellate efforts, on the ground efforts, I mean, there's a full menu of options. Whatever you're doing, please share it on the national listserv so that we can help each other and share the information about what's going on the ground. So again, my thanks to Allison, Deanne, Ashley, and all of you for being here, and very much look forward to continuing this work with you around the country. Take care, everybody.